Justice Thomas has the opinion of the Court in Case 16-1140, Nifla versus Becerra.
This case comes to us on a writ of certiorari to the United States Court of Appeals for the Ninth Circuit. The California Reproductive Freedom, Accountability, Comprehensive Care, and Transparency Act was enacted to regulate crisis pregnancy centers, which are, for the most part, pro-life organizations that offer pregnancy-related services. The Act requires clinics, primarily serving pregnant women, to provide certain notices. Licensed clinics must notify women that the state of California provides certain services, including abortions, and must give them a phone number to call. Unlicensed clinics must notify women that California has not licensed them to provide medical services. Petitioners filed suit alleging that both notices abridge the freedom of speech protected by the First Amendment. The District Court denied their motion for preliminary injunction, and the Ninth Circuit affirmed. In an opinion on file with the clerk today, we reverse. Starting with the license notice, we hold that it likely violates the First Amendment. Content-based laws are presumptively unconstitutional and may be justified only if they satisfy strict scrutiny. The license notice requirement is a content-based regulation because it compels petitioners to speak a particular message. Although this requirement is content-based, the Ninth Circuit did not apply strict scrutiny because it concluded that the notice regulates professional speech. But this Court has never recognized such a category of speech. Speech is not protected or unprotected merely because it is uttered by professionals. This Court has afforded less protection for professional speech in two circumstances: commercial disclosures that are purely factual and uncontroversial, and regulations of professional conduct. Neither of these categories turns on the fact that professionals are speaking, and neither is implicated here. Beyond these two contexts, our precedents have long protected the First Amendment rights of professionals. No party or court has advanced a persuasive reason for now applying different rules to an amorphous category known as professional speech. Such a reason may well exist. Here, though, we do not need to consider the question further because the license notice requirement cannot satisfy even intermediate scrutiny. The notice is under-inclusive, perhaps wildly so. It does not apply to similar types of clinics that are just as likely to serve the low-income women that California says it wants to inform. And California has less intrusive ways to inform women about its services, such as its own public information campaign. We hold that the unlicensed notice also likely violates the First Amendment. It is unnecessary to decide whether the standard for commercial disclosures established by our decision in Zouderer applies. Even under Zouderer, the unlicensed disclosure fails because it is unjustified and unduly burdensome. The only stated justification for the unlicensed notice is ensuring that pregnant women know when they are receiving medical care from licensed professionals. But California disavowed that justification at oral argument. Even if it stood by this justification, the unlicensed notice requirement is an unduly burdensome method of achieving it. The unlicensed notice imposes a government-scripted, speaker-based disclosure requirement that is wholly disconnected from California's supposed interests. For these reasons and others set forth in our opinion, we reverse the judgment of the Ninth Circuit. Justice Kennedy has filed a concurring opinion in which the Chief Justice, Justice Alito, and Justice Gorsuch have joined. Justice Breyer has filed a dissenting opinion in which Justices Ginsburg, Sotomayer, and Kagan have joined.
As you just heard, Justices Ginsburg, Sotomayer, Kagan, and I dissent. The main issue in this was that the California statute's requirement that licensed pregnancy-related medical clinics must post a notice telling patients that the state offers financial assistance for family planning services, including prenatal care and abortion. The majority holds that this statutory provision violates the First Amendment. We disagree with that holding for 4 reasons. First, we find the basic reasoning on which it relies is flawed. The holding rests upon the conclusion that the provision requires particularly careful or heightened scrutiny, or strict or medium or something, but it's heightened scrutiny by judges because it is a, quote, content-based law. Now that, in its view, means that the law requires individuals to, quote, speak a particular message. Now the problem is that the same exactly can be said of legislation all over the place. Ordinary health, economic or social regulation does the same thing. But precedent has long required courts to take a more deferential attitude towards legislative decisions of an economic and social kind. What about laws requiring hospitals to talk about vaccines or seat belts, or laws requiring landlords to talk about their tenants' garbage disposal rules, or laws that regulate securities, or laws that regulate consumer products, or laws that regulate professionals, doctors, lawyers, engineers, accountants, to disclose information to their clients? There are even disclosure laws relating to petting zoos. These laws do not involve the rationale for heightened First Amendment scrutiny, for example, fear of viewpoint discrimination, nor is it clear which of them might find shelter under the exceptions that the majority seeks to provide. Thus, putting the particular case before us to the side, we fear that the majority's approach will, on the one hand, allow judges too great a constitutional authority to hold invalid, under the First Amendment, legislative decisions about the merits of economic or social legislation with which they disagree. And on the other hand, to have this content regulation rule will diminish because of its dilution as you apply it to social and economic legislation, our understanding of the very critical free speech values that the First Amendment seeks to advance. Now, our second objection, and that has to do with this particular case. The majority, we think, pays inadequate attention to precedent that we find directly on point, namely cases involving disclosure in the context of abortion. In Planned Parenthood versus Casey, the court upheld a law. It said it was okay, that law, the state had passed, requiring doctors to tell women, pregnant women, for example, about state resources for adoption services. The court held that the law did not violate the First Amendment because the law was part of the practice of medicine subject to reasonable licensing and regulation by the state. That's telling women seeking an abortion about adoption. Now, if a state can lawfully require a doctor to tell a woman seeking an abortion about adoption services, why can it not require a medical counselor to tell a woman seeking prenatal care about childbirth and abortion services? After all, the law must be even-handed, and that is particularly important in a case involving abortion rights. And that's because Americans do hold strong and differing moral views about abortion. We, a court, cannot adjudicate who is right and who is wrong in this moral debate. But we can do our best to interpret the American Constitution so that it applies fairly and even-handedly within a nation whose citizens strongly hold different points of view on the question. The majority tries to find distinctions. It says that Casey, which involved disclosure about adoption, involved informed consent to a medical procedure, but our case does not. Oh, really? Does birth not involve a medical procedure? Our case does involve medical personnel. It does involve a woman's decision to carry a child to term, and it does involve the many equally serious or more serious health risks that are involved when a woman gives birth. So where is the difference? Third, we disagree with the petitioners in respect to a matter that the majority does not consider. The petitioners, supported by amici, argue that the California statute violates the First Amendment because it discriminates on the basis of point of view. It considers it to a degree, the majority. These clinics that will have to post the notice, they say, are primarily those with moral objections to abortion. But because there are exceptions in the statute, those who do not have those objections don't have to post the notices. Now, the problem with this argument, which in principle is a legitimate argument, is that there was no evidence presented on this matter in the lower courts. Is there, for example, in terms of the statute's objectives, which is informing lower income women about their options, is there a similar need to cover the clinics that the statute accepts? There's no evidence on that point. In our view, the lower courts can take evidence on the point and related points and then decide. There is no basis, we think, for deciding that question here and now. I don't think we can. There's no evidence. Fourth, California law separately requires unlicensed clinics that provide certain medical-type services, for example, perform ultrasounds, diagnose pregnancies, or provide pregnancy counseling, to tell clients that they are not licensed. The state says that it passed this law to ensure that, quote, pregnant women in California know when they are getting medical care from licensed professionals. All right? Unlike the majority, we think this law is adequately justified by what is a classical disclosure legislation rationale. Namely, it's there, so pregnant women in California know when they are getting medical care from licensed professionals. The majority says the law is too burdensome, requiring, for example, posting notices in 13 languages in Los Angeles County. But those burdensome-related objections don't show that the statutory provision is unconstitutional in its face, i.e. across the board, i.e. everywhere. Rather, they are properly raised in the form of objections to the statute as applied. If they think there's something wrong with Los Angeles County and the 13 languages, then bring it in respect to Los Angeles County and the 13 languages, and let's see. All right. Now, those are our basic reasons. There are others in the opinion. These are spelled out more fully. And for those reasons, basically, we dissent.